各位早晨，咁咧歡迎大家嚟到呢個記者會啦。咁咧就我哋可能首先影咗張大合照先，影咗張相先，好嘛？好啊。如果可以嘅話咧，就係啦。咁我哋跟住再繼續啦。咁就多謝大家今日嚟到我哋呢一個法律改革委員會發表與仲裁結果有關的收費架構諮詢文件嘅記者會啦。咁首先我哋介紹下今日嘅記者會嘅講者啦。喺左耳呢一邊呢一位咧，就係法律改革委員會轄下與仲裁結果有關的收費架構小組委員會嘅聯合主席張清明女士 ，Miss Catherine Sanger。跟住喺主席嘅左手邊呢，係小組委員會嘅成員盧君正博士 Dr. Benny Low。咁我旁邊呢位呢，就係法律改革委員會秘書長尹平少女士。另一邊呢，就係小組委員會嘅秘書馮淑芬女士嘅。咁首先我哋呢，就會請主席介紹一下諮詢文件嘅內容，之後呢，就再有答問嘅環節，就等大家提問嘅。咁may I invite our co-chair to give a brief introduction on the consultation paper, please?
Thank you, Olivia. Ladies and gentlemen, it is my pleasure on this wintry Hong Kong morning to present to you the consultation paper of the Law Reform Commission's Outcome-Related Fee Structures, a bit of a tongue twister for Arbitration Subcommittee. We refer that to ORFS for short in the report. The subcommittee was given the task of reviewing the Hong Kong legal position related to outcome-related fee structures for arbitration taking place in Hong Kong. For the purposes of the paper, outcome-related fees are fees that a client pays its lawyer for working on litigation or arbitration proceedings, and which are payable only if the client wins its case. And these are often known collectively as the more easier term to say success fees. Now, currently Hong Kong law does not allow lawyers to charge outcome-related fees for contentious work, whether it's litigation or arbitration. The professional conduct rules of Hong Kong, barristers and solicitors also prohibit such types of fees. Now, our remit was to consider whether reform is needed to the relevant laws and regulations in the arbitration context, not the litigation context, and if so, to recommend any reforms we think are appropriate. Now, the subcommittee met on a regular basis, and in the course of our review, we considered the law relating to success fees to outcome-related fee structures for arbitration in a number of other leading arbitration seats. These include Singapore, England and Wales, Australia, mainland China, the USA, and leading civil law jurisdictions such as France, Sweden, South Korea, and Switzerland. We also looked at the previous Law Reform Commission consultation on conditional fees for contentious proceedings, and that includes arbitration but also litigation, between 2003 and 2007, as well as the consultation on third-party funding, which took place between 2013 and 2016. And the committee, having done that research and having looked at the position in Hong Kong, unanimously concluded that Hong Kong should lift its prohibitions on the use of success fees or outcome-related fee structures for arbitration. Now, we did not consider, and we are not recommending, removing the prohibition on success fees for litigation proceedings in the Hong Kong courts. Our remit, as I've said, was limited to arbitration proceedings, like the third-party funding reform, and to court proceedings, but only in support of the arbitration proceedings, as well as to work done by Hong Kong-based lawyers on arbitrations seated outside Hong Kong. So that's the introduction. I apologise, my mask is slipping. I will try to keep it above my nose. So just to give you some background on the paper and the main considerations behind our recommendations. Now, just to emphasise again, an outcome-related fee structure is an agreement between lawyer and client whereby the lawyer is advising on contentious proceedings, and that's important, and the lawyer receives a financial benefit only if those proceedings are successful within the meaning of that agreement. There are 3 types of success fee agreements that we've dealt with in the paper. The first are what we call conditional fee agreements, and these are abbreviated to CFAs in the paper. And this was the remit of the consultation in 2003 to 2007. The second type that we talk about are damages-based agreements, and these are abbreviated to DBAs, also known as contingency fee in some jurisdiction. And the third type is a hybrid DBA, and these are called, unsurprisingly, hybrid DBAs. And I'll talk about all 3 types in the course of this introduction. Now, at present, lawyers in Hong Kong are prohibited from charging any form of success fee, whether that's a CFA, a DBA, or a hybrid DBA, on any contentious proceedings, and that includes arbitrations in Hong Kong, and also arbitrations outside Hong Kong if the lawyer is in Hong Kong. By contrast, and this is important, most leading major arbitration seats permit lawyers to charge some form of success fee for arbitrations taking place within their jurisdiction. The one exception is Singapore, and Singapore recently had a similar consultation that's finished in October last year, and we're awaiting the outcome on conditional fee arrangements, again, for arbitration. So Singapore is also looking at this, just as Hong Kong is. Now, in looking at the review and in carrying out our research, we have been mindful as barristers and practitioners and academics that there is increasing client demand for flexible alternative price and funding options for arbitrations in Hong Kong. It can be an expensive process. And it's important again to note that we're not just talking about clients who can't afford to pay the lawyer's fees, impecunious clients with meritorious claims. We're also talking about an increasing number of clients who want to take the litigation risk off their balance sheets, and they really want their lawyers to have skin in the game with them. They want their lawyers to be aligned in the outcome and the success of the proceedings. And one of the historical sort of objections to success fees has been a sort of conflict of interest point. And in fact, when you look at it, there is really in some ways lawyers and clients' interests are more aligned in a success fee situation because the lawyer has an interest and it senses aligned with the client in terms of how those proceedings are resolved and whether they are successful or not. Now, clients who are arbitrating in Hong Kong are generally sophisticated. They're usually commercial clients, and we can talk about that. And these clients are free to seat their arbitrations anywhere they want to in the world. And what we are trying to do is put Hong Kong on an even playing field with those jurisdictions. We want Hong Kong lawyers to be able to compete with their counterparts in those jurisdictions, including in China, where contingency fees have been permitted for a number of years. And we think that clients will increasingly look to choose to arbitrate elsewhere and to use lawyers outside Hong Kong in jurisdictions where outcome-related fees are permitted and have been now permitted for some time if Hong Kong does not follow suit. And we talked about this, but an important aspect of arbitrations involving mainland Chinese parties. We see an increasing number, as a practitioner, I would say over 50% of my cases involve mainland China in some aspect. we are seeing an increasing number of arbitrations involving Chinese parties who are increasingly willing to become claimant in arbitrations and fight to protect their rights. And we have seen the number of those cases rise, in particular in context with the Chinese, the Belt and Road Initiative. And these claims are increasing day by day. Now, mainland China, as many of you will know, permits lawyers to charge outcome-related fees for arbitration work. These arrangements are in fact common, if not standard, there, and allowing Hong Kong lawyers to do the same puts them on an even playing field with their mainland Chinese counterparts. And this, we say, this is just one example why it is more important than ever for lawyers in Hong Kong to be able to fund their cases on the same, or at least similar, basis. And that's why we consider that permitting outcome-related fee structures is essential to maintaining Hong Kong's status as one of the world's leading arbitration seats. So, just taking a bit of time to look at the recommendations. These are, as you will be familiar with, at the back of the report. There are 14 recommendations altogether. Recommendations 1 to 3 deal with conditional fee arrangements, so CFAs, and we split them into 3 categories for ease of navigation. Recommendations 4 to 10 deal with damages-based agreements or hybrid damages-based agreements. And recommendations 11 to 14 deal with the legal and regulatory framework for both types of structures. So, the recommendation to lift the current prohibitions can be found in 1, 4 and 10. We unanimously concluded that Hong Kong should lift the current prohibitions on the use of outcome-related fees in arbitration. And this conclusion is set out in recommendation 1 for CFAs, recommendation 4 for DBAs, and recommendation 10 for hybrid DBAs. We also made a number of recommendations about the operation of the individual regimes relating to CFAs, DBAs, and hybrid DBAs, and again, drawing from our research in other jurisdictions in particular, and seeing what's been successful in those jurisdictions. In the context of CFAs, the success fee is the additional fee that the client agrees to pay the lawyer if its case succeeds. So what usually happens is that the client will pay the lawyer a discounted fee for the duration of the proceedings, and if that claim is successful or the case is successful, however success is defined in the agreement between the lawyer and the client, then there is on top a success fee which is benchmarked by reference to a percentage of the normal cost that the lawyer would have charged for the case. So to give you an example, a lawyer may charge 75% of normal rates for the duration of the arbitration, and if that arbitration is successful, then the lawyer may charge an additional 25, so 125% in total, only if that case is successful. Now, in that context, we have recommended that the success fee element should not be recoverable from the other party, from the losing party in the arbitration. This is the case even if that party, let's call it the respondent, has to pay the claimant's normal fees in the usual course. Now, England and Wales, which has for a very, very long time now allowed conditional fee arrangements, at one stage allowed successful claimants to recover that success fee element from the losing party as well as their usual costs. And this not only led to a number of satellite litigations, because of course the respondent was incentivized to challenge the enforceability of the the conditional fee agreement, but it also attracted heavy criticism about the fairness of making a losing party responsible for a success fee that the other side has agreed between itself and its lawyer. Why should the losing party be responsible for that fee? And so England ultimately changed its regime so that success fees are no longer recoverable from the losing party. Likewise, at the subcommittee, we also considered it is inherently unfair to make success fees recoverable from the losing party, because the losing party really has no control over the arrangements that it meets with its lawyers, the winning party meets with its lawyers. And so we also recommend that claimants should not be allowed to recover the success fee from the losing respondent either, and that's a matter for client lawyer. And it's relevant, I think, to note that that's also consistent with the view that was taken in the earlier consultation on conditional fees between 2003 and 2007. Likewise, we also recommend that there be a cap on the success fee. Again, this is consistent with other jurisdictions, and that will be a cap on normal percentage or benchmark costs. In England and Wales, that cap is 100%. So a lawyer can charge up to 200% of benchmark costs in a success situation. In Australia, for contentious proceedings, it's a lower cap at 25%. Now, in many cases, that success fee will be pure profit for the lawyer. And so, as the subcommittee, we felt that there was scope for capping the success fee at lower than the 100% cap that is applicable in England and Wales. So we have sought specific consultation on whether there should be a cap, and if so, what that cap should be and why. We also recommend, and this is recommendation 7, that there will be a cap on the DBA payment that the client pays its lawyer. And the DBA payment is a reference to the outcome of the proceeding. So often it's expressed as a percentage of the spoils that the client wins in the arbitration. And we think that the DBA payment should be expressed as a percentage of the financial benefit or the compensation received by the client. And the reference to financial benefit is deliberate because we want that term to be as flexible as possible. And in England and Wales, the cap for the DBA payment is 50% currently. There is a recommendation that be dropped to 40%, depending on the fee model that's adopted, and I'll come on to that. It's fairly complicated, but it's dealt with in detail in the paper. In mainland China, it's 30%. So again, we recommend that there be a cap, but we also seek consultation on what that cap should be and why. We also deal with scenarios around termination of the agreements, and whether in circumstances where a success fee agreement is terminated by the client or even the lawyer, how fees should be charged in that scenario, and you'll see that in the paper. And that draws on experience that we've seen in England and Wales as to how termination of agreements has unravelled. Recommendation 6 deals with the success fee model that I just talked about in the context of DBA payments. It's fairly complicated, but it's to do with the ability of the winning party to recover costs from the losing party. Now, in Hong Kong, like many common law jurisdictions, the basic principle in litigation, and this also applies in arbitration, is that the winning party can recover from the losing party all or at least some of its costs of pursuing the litigation or the arbitration. Usually it's reasonable costs. But those costs are not a punishment on the losing party, nor are they intended to be a windfall for the winning party. And so there is what's called the indemnity principle. So the losing party cannot be asked to pay more than the winning party has to pay its lawyers, otherwise the winning party would receive a windfall. And that is the basis behind the two fee models that are used in DBA payments. There are two models. One is known as the Ontario model, based after the Ontario, where these models are used in Canada, and that's the model that currently applies in England and Wales. The second model is the success fee model, and that model is currently under recommendation in similar reform that's ongoing in England and Wales now. So the recommendation that's been made in England and Wales is to switch from the Ontario model to the success fee model. Under the Ontario model, the winning party cannot recover from the losing party the full DBA payment that it has to pay its lawyer, if that would be higher than the cost that would be recoverable from the losing party if there's no DBA in place. In those circumstances, the winning party has to fund the shortfall out of its own pocket, so it has to pay the balance out of its own pocket to its lawyer. Conversely, if the DBA payment is lower than the usual recoverable costs, then the DBA payment acts as a cap on the amount of cost that can be recovered from the losing party, and that's the operation of the indemnity principle. By contrast, under the success fee model, the costs recovered from the losing party are treated as being entirely separate from the DBA payment. And that's seen as being inherently more straightforward, easier for clients to understand, and gives rise to less satellite litigation. So that's the current recommendation in England and Wales. And for the same reasons, the subcommittee also seeks consultation on which model should apply if DBA payments are permitted in Hong Kong for arbitration, and we recommend the success fee model for the same reasons. Finally, the recommendations in 11 to 13, simple and clear legislation. We have considered how best to implement the legal and regulatory changes that are required to lift the prohibitions in relation to arbitration. We consider that it would be necessary to amend the arbitration ordinance, the legal practitioners ordinance, the Hong Kong Solicitor's Guide to Professional Conduct, and the Hong Kong Bar Association Code of Conduct. We also recommend that the detailed regulatory and subsidiary legislation dealing with the specific details of how to implement these fees should be contained in subsidiary legislation. That means that it can be drafted clearly, it can be drafted as a standalone piece of legislation, and it can also be amended much more easily than if it's embedded in the main legislation. And finally, in recommendation 13, and you will see this set out in detail in the paper, we invite submissions on a number of safeguards which we consider should be put in place to mitigate any risks that have historically been associated with outcome-related fee structures. And we also welcome comments on whether there are any types of specific claims, for example, personal injury claims, should they be treated differently to general commercial arbitration? Should they be carved out of the regime altogether, or should they be subject to different caps or safeguards than under the general regime? So that deals with the recommendations. The consultation period is 3 months from technically yesterday, I think, so it finishes on the 16th of March 2021. The subcommittee welcomes views from everybody as far-reaching as possible on the paper, and we look forward to receiving feedback on our recommendations. So that introduces the paper. I hope it's given you a feel for what we've done over the past few months. It's been a very interesting and rewarding exercise for us as a subcommittee, and we would be pleased to answer any questions that you have about the paper. Thank you.
Thank you, Ms. Simon. 而家係答問嘅時間，大家對呢個諮詢文件有咩問題就歡迎提問嘅。係新城嘅。
Hello， 新城嘅，因為我哋中文電台想問翻一啲中文幣嘅，即係可唔可以簡單講下點解今次小組委員會想採用呢個新收費架構，其實有咩好處呢？或者係其實現有嘅收費模式，你覺得係有啲咩問題可以要轉一個新模式呢？或者係外國有啲咩經驗可以值得香港參考呢？另一個就係講到關於小組委員會建議應按損害賠償收費協議費用設定上限。點解要設定上限呢？或者係個上限應該係定喺邊個位度呢？個數限係應該按 percentage 啦，定係按一個某一個金額嚟定啦？唔該。
So,
多謝提問嘅嚇。咁首先答第一個問題就話點解我哋喺而家呢個階段咧需要檢視啊，同埋考慮需唔需要作出相關嘅改革啦。咁其實咧，我哋頭先正如張主席都介紹過，其實咧香港咧作為呢一個國際仲裁中心嘅樞紐咧，其實一個都係一個係已經係眾所周知嘅事實嚇。咁我哋咧喺國際上亦都睇過檢視過咧，其實喺所有嘅領先嘅國際仲裁中心嚟講咧，其實除咗新加坡以外咧，其實咧喺 喺嗰啲其他嘅大部分幾乎全部呢啲領先嘅國際仲裁中心咧，都已經係容許某程度上嘅同仲裁結果有關嘅收費架構嘅。咁所以咧，如果我哋要保持同埋要提升香港嘅地位，作為呢個繼續成為呢個國際仲裁中心嘅之一嚟講咧，如果我哋係唔做呢樣嘢咧，亦都會係相對嚟講令我哋係未必能夠保持到呢個地位。咁所以我哋覺得必須要與時並進，係繼續做呢樣嘢。頭先張主席亦都介紹過，其實咧我哋發現到咧，其實越嚟越多嘅當事人參與國際仲裁嘅當事人嚟講咧，亦都係有呢個咁嘅訴求，有需求咧係話其實咧可唔可以香港嘅律師或者甚至係任何律師喺香港做仲裁嘅時候咧，收取呢一方面嘅呢一種咁嘅收費架構。但係如果我哋做唔到嘅話咧，咁其實國際嘅呢啲咁嘅仲裁當事人咧，好有機會咧，其實佢哋可以有自由選擇係用任何一個領先，例如新加坡啊，例如紐約啊、歐洲嘅城市啊去做呢個仲裁地嘅。咁但係如果咁樣嘅時候咧，香港咧，如果我哋要繼續發展呢個爭議解決中心、國際仲裁中心嚟講，就會落後咁樣咯。咁至於細節上嘅理由，頭先張主席都介紹過，唔再重複啦。咁至於話第二嗰個問題就關於話我哋係做呢個無論係按條件收費或者係按呢個損害賠償嘅方式嚟到去計算呢個律師費嘅時候咧，點解我哋要 set 一個上限咧？即係定一個上限咧？其實呢個咧都係我哋係想同翻咧國際嘅做法一致。國際做法嚟講咧，正如頭先都介紹過，英國嚟講咧係上限就按條件就去到100%嘅100%。至於其他地方有可能去到40%啊30%。咁我哋覺得咧，其實我諗相信背後嘅理念咧，其實都係話咧，其實由於呢個係一個對一個律師嚟講係一個純利潤嚟嘅，一個 profit 嚟嘅。就我哋唔想話點講，唔想話將成件事太過即係商業化得太過極端。咁我相信個理念咧就係話咧，我哋雖然係容許律師因為佢冒咗個風險，去到咧用佢嘅時間啊或者各樣嘅資本去資助，因為當事人去到打呢個仲裁，但係咧其實我哋對佢個利潤嗰個上限咧，其實都應該有翻一定嘅規管咁樣嘅。咁個理念就係咁樣嚇。希望解答到你問題，唔該。
商台係咪？
你好啊，商台都係想問翻中文問題先嘅，想講多啲即係提升嗰個競爭力嗰方面咯。可唔可以即係一般市民嚟講，即係有咗呢一個制度，點樣幫佢哋理解即係提升競爭力？好似頭先主席有講話，即係對於律師嚟講，佢哋個 interest 就會即係同客人比較即係接近啊，要 rely on 佢哋 outcome。即係可唔可以喺呢方面中文解釋多啲，點樣去影響律師喺仲裁入面個發揮，然後再影響香港即係作為個中心嘅競爭力？唔該你。
或者我先用中文嚟回答呢個問題，多謝問題。咁其實我先解釋多少少背景嚟講咧，我哋一般嚟講嘅仲裁嚟講咧，係前提咧係需要有一個仲裁協議嘅。咁仲裁協議咧就會一般嚟講咧喺一般嘅商業嘅合同裡面咧就會係可能其中一條條款就話咧，如果發生咩嘢爭議嘅時候咧，就會係去仲裁解決，就唔係去法院解決。咁嘅時候咧，大家當合同嘅雙方去決定喺個仲裁條款裡面話發生爭議之後，去邊個地方去處理仲裁咧，係有絕對嘅自由度嘅。咁當然啦，佢哋考慮去邊個地方嘅時候，亦都會考慮好多因素。個因素咧就包括譬如當地係咪一個奉行或者係受呢個紐約公約條款，即係我哋去執行同埋去到強制執行呢啲仲裁裁決嘅一個嘅國際條約嘅受約嘅一個締約方啦。第二樣嘢咧，亦都話當地嘅司法機構有冇一個好好嘅支援有冇一個好好嘅去支援，尤其是係關於執行仲裁裁決方面嘅條件。咁當然而家咧，其實話而家我哋今次呢個小組委員會去諮詢呢一件事咧，其實都會係一個考慮之一嚟嘅。因為點解咧？因為正如頭先張主席所解釋咧，其實咧佢哋一有比較嘅時候咧，就話喺嗰啲某啲其他嘅仲裁地，其實 in fact 喺最大部分嘅仲裁地，除咗新加坡之外，到目前為止都可以係用呢個咁嘅按仲裁結果嘅嘅結果嚟講咧嘅收費咧架構嚟講咧，但係香港做唔到嘅時候，呢個必然咧係會對一般嘅商業上嘅當事人嚟講咧，係會係考慮到究竟喺嗰條仲裁條款裏面，我哋係咪定香港啊，定抑或定喺第二啲地方去做仲裁咁樣嘅？如果一定咗之後咧，就嗰份合約嘅爭議嚟講就冇得改㗎啦，除非之後雙方突然間又去同意去修改咁樣咯。咁所以喺呢一方面，我哋係吸引咧，係想希望唔想香港咧係落後於其他嘅仲裁地啦，係可以做呢樣嘢。咁所以咧，我哋希望咧就係可以去檢視呢方面啦，亦都係建議一方面嘅改革，令到咧大家嘅當事人嚟講，香港唔會落後於其他嘅地方，能夠保持佢嘅競爭力同埋吸引性咁樣嘅。
新台仲有。
提醒過。
個問題未答就係點樣會影響即係律師嗰個發揮啊？即係有個彈性，其實對當事人個好處係乜嘢？唔該。
其實咧正如頭先張主席都介紹過嘅，其實就係話其實呢方面嘅需求啊，即係話需求去用仲裁結果有關呢種咁嘅收費模式咧，其實好大部分係嚟自於當事人本身嘅。當佢嚟於當事人本身，如果律師同佢講就話唔得啦，香港嘅法律如果暫時嚟講咧係唔容許呢樣嘢嘅話咧，咁首先第一去到讓香港嘅律師能夠可以去好滿足到當事人嘅需求呢方面就已經有啲落後。咁呢個就係但係可能咧當然啦係。當喺嗰個案件發生嘅時候咧，已經係大家已經簽咗仲裁條款嚟香港。但係咧，其實我哋唔能夠咧咁短視，淨係睇一個案件嘅。其實喺將來嚟講咧，其實咧佢哋會覺得原來香港今次唔得喎。咁第日咧，可能佢哋會簽嗰個條款嘅時候咧，就會決定咧去可能選擇第二啲嘅仲裁地會比較好啲。唔知答唔答到你個問題咧？
好，跟住 Now TV。
而家都想問下盧博士一啲即係技術少少嘅問題咧，因為見到嗰個收費架構其實係由嗰個按條件收費啦、按損害賠償收費協議同埋可以混合咁樣去做。其實嗰個技術上係譬如仲裁案件係咪唔同嘅仲裁案件會用唔同嘅收費，定係其實係即係咩時候會選用邊一個嘅收費模式咧？即係有冇一個咁樣嘅説法啦？同埋即係譬如嗰個按損害賠償收費協議咧，嗰個效果會唔會變咗係即係好似瓜分當事人嗰個賠償咁樣樣㗎？
我叫我同事先回答，如果有咩補充，我會再查。
It's really a matter of client demand. There won't be a sort of prescription that for a particular type of arbitration you have to have a particular type of fee structure. It's really a matter of how the client usually would discuss with its lawyer what the options are available. And the difference between a DBA and a CFA is that the CFA normally, the success fee is determined by reference to a percentage of benchmark costs. The DBA is determined by reference to the winnings or the success element in the claim itself. So they're different. Now, historically, DBAs have been found to be well suited to complex, high-value, long-running arbitrations. The reason for that, and the reason why we have also recommended hybrid DBAs. Now, hybrid DBAs are not permitted in England and Wales, which is a jurisdiction we looked at closely because it's very similar, but is under recommendation. Lord Justice Jackson and the team in England, it's called Professor Mullihan and Mr. Bacon QC, have also recommended that hybrid DBAs be permitted. And the reason for that is because of the risk that a lawyer takes on in a DBA context. In a 5-year arbitration, it's a very long time for the lawyer not to be paid and a lot of risk. So DBAs have not been as popular as CFAs in England and Wales. And so the hybrid allows a lawyer to charge a low fee throughout the lifetime of the arbitration, and then to have real skin in the game with the client in terms of the outcome. And it can be very successful for both lawyer and client, and equally it's a risk that the lawyer takes on. And the reason for allowing hybrid is to make the DBA option more attractive to both lawyers and clients. And it also benefits the client because at the moment you can have a hybrid DBA offered by a third-party funder. So often a third-party funder will provide funding to the lawyer to fund the arbitration, and then the third-party funder will take a cut of the winnings from both client and lawyer. So the client ultimately ends up paying more. And so a hybrid DBA allows a lawyer to step into the shoes of the third-party funder and to allow a sort of a low-grade financing throughout the arbitration, and then a DBA payment if and only if the claim is successful. So again, I hope that answers your questions. Really, it's all about client demand and really freedom of contract in Hong Kong. Freedom of contract is a cornerstone of the legal position in Hong Kong. And what we are having to do at the moment is say to clients, we can't even have this discussion with you. We are regularly asked, can you do some form of success fee? Can you do a DBA arrangement? We don't want to pay you anything or pay you very little, but if we win together. And that discussion is happening every day in China and we can't have it in Hong Kong. So it's really, really about what the clients want and providing a full menu. So if we have reform in relation to CFAs, let's go. There's no reason not to do it for DBAs and hybrid DBAs as well.
即係個感覺係瓜分賠償嗰個效果咧，即係會唔會呢一個可以用中文解釋翻？
其實多謝問題先嗱，咁其實呢個所謂瓜分賠償呢個講法咧，其實咧就係適用於咧，只係適用於三個之中其中兩個選項嚇，就係嗰個關於話按損害賠償嚟收費協議啦，同埋另外一樣就係話叫做混合式嘅按損害賠償。咁無可否認咧，其實你話係咪話有好似瓜分賠償咁嘅感覺咧？咁其實呢個事實上亦都係咁嘅嚟嘅嚇。咁但係呢個問題就係話，始終而家客戶如果佢係願意咁做嘅，而係知悉晒嘅全個安排同埋協議裏面嗰啲嘅權利啊、義務啊，同埋可能我哋建議亦都係我哋諮詢嘅其中一部分，就係有啲咩保障嚟講咧，同埋監管方面嘅嘢咧，其實我覺得喺就呢個仲裁，尤其是仲裁嘅當事人嚟講咧，就我相信咧問題唔係咁大嘅嚇。一般嚟講，我哋可能聽到喺傳媒啊或者各處嘅聽到話咩瓜分賠償呢個咧，好多時咧其實就係有啲適用於一啲個人嘅訴訟人嚇，就係佢哋咧可能唔係好知道自己嘅權利義務，咁咧就咧有受一啲中介啊中介或者一啲非唔誠實嘅律師啊，咁去影響咗嘅話咧，咁咧佢咧就會可能會佢嘅權利被剝削。但係我哋而家今次我哋諮詢呢個諮詢文件裏面咧，聚焦咧只係聚焦於呢個仲裁方面，甚至係其實國際仲裁。個仲裁裏面咧參與嘅當事人嚟講，就唔係我哋一般或者會用呢個瓜分賠償呢個咁嘅呢個標籤啦，或者呢個字眼啦去形容嗰啲嘅情況咯。所以我哋就呢方面嘅擔心就唔係咁高嘅。其實但係我哋咧點都好啦，正如頭先張主席都有解釋嘅，但係我哋咧亦都會了解到咧，可能咧有時候可能有啲人身傷害嘅賠償啊，可能理論上咧係可以做仲裁嘅，或者甚至有啲其他嘅類別嘅爭議解決都可以做仲裁。咁所以我哋特別係考慮到咧，會唔會有需要就某啲種類嘅爭議，可能會比較容易相關嘅當事人可能會比較容易受呢啲咁嘅剝削或者咩嘅情況之下咧，去作出相應嘅保障嚇，或者甚至咧我哋話可能我哋需要定嗰個上限會定得比較低，或者另外一個方法甚至嚇如果有啲人嘅意見可能會覺得某啲類別咧根本就應該排除喺呢個嘅架構之外嘅，呢個我哋都好願意，亦都好希望能夠聽到公眾嘅意見啊，咁所以就希望會咁樣就會全盤咁去保障到所有嘅當事人嘅。
好，咁樣東方。
你好啊，有幾個問題想問。第一個想問翻呢，因為我見到你哋係有兩個方案係不成功不收費同埋不成功低收費啦，但係我就未見到話有為呢個低收費訂立一啲標準，反而係我見到你哋可以寫住係按慣常收費率就收費嘅。如果失敗嘅話，咁如果係咁嘅話，會唔會造成即使我輸咗就會負債，而我贏咗亦都唔會攞到幾多錢呢？咁會唔會係為咗呢？會唔會就呢一個不成功而訂立一個最高嘅收費標準呢？想請問下。另外就係我都未見到啲文件都見唔到有呢個懲罰嘅機制啦。想問下你哋都會唔會考慮喺某程度上係針對律師作出有任何嘅懲罰機制去限制有任何違規嘅情況呢？最後想問翻呢，因為你哋主要都係強調今次嘅改變咧，都係受到國際仲裁啊，又或者係一啲商業化啲嘅仲裁所作出啦。但係會唔會有一啲本地嘅制度上嘅問題，都令你哋覺得需要呢一個作出呢一個改變法律嘅舉動咧？例如係會唔會覺得而家香港嘅法援制度冇咩有一啲限制啊，令到某啲人冇得受惠，而影響到佢哋索償嘅意欲或者機會，所以你哋都會有幫助到呢一班嘅人呢？唔該晒。
我都係想請張主席先回答呢個問題。
I think taking the last question first, in terms of the changes to the legislation, that there would need to be changes to the legislation, first of all, to permit these types of fee arrangements for arbitration only. That's the first point. There would also need to be subsidiary legislation dealing with the safeguards to be put in place around these arrangements. For example, requiring a client to take independent legal advice before entering into a fee arrangement with its lawyer, having a cooling off period, making very clear what the financial benefit means under the terms of the arrangement, and you will see that dealt with in recommendations 11 to 14 in the paper. In terms of the penalty aspect, I think there are two parts to this. We have recommended that the professional codes of conduct deal with the requirements that lawyers have to follow in order to comply with the regime to protect clients and the public. And that means that trivial breaches can be dealt with by the professional bodies on an easy basis. If there were more serious breaches, then that would be a matter covered by the legislation, and it would be something that the lawyer could be sanctioned for. Unclear what penalty would be, but certainly it would be dealt with in the legislation. In relation to the loss aspect, the point is, in a no-win, no-fee, no-win, low-fee, if there is no win, the lawyer either gets nothing, and that's the risk the lawyer takes in deciding whether to take on the case and what arrangement to do with its client. And this is a mutual agreement between lawyer and client. If it's no win, low fee, then again that's really a matter of agreement, and the client may say, well, I'd like to pay you only 25% of your costs, and if I lose, that's all you get. And that's really a matter for contract between the client and the lawyer, and we don't see any need to sort of have a cap or stipulate, because that's really for the client to negotiate with the lawyer. And really, the more risk the lawyer takes, perhaps then that would be reflected in what happens if there is a success. But it's for a lawyer and a client to have that discussion and to decide what the relative merits of the case are. And in that context, we have also sought consultation on what does success mean. So in a damages-based scenario, at the moment in England and Wales, then the lawyer only gets paid if there is a recovery of damages. So the claimant receives an award for damages, and that award is successfully enforced. So the client has money in hand and then will pay a proportion to the lawyer under the agreement. But financial benefit could be a number of things. And so, for example, if you're a claimant and you have a counterclaim for 100 million Hong Kong dollars against you, and you manage to resist that, and your lawyer is successful in having that counterclaim rejected, then that's quite a significant benefit. You may be awarded a piece of land, you may have a debt discharged, and so we also seek consultation on being as flexible as possible on what financial benefit means, and that's really for the client's benefit as much as the lawyer.
即係我或者回應翻咧，或者補充少少最後嗰個問題咧，就係話關於我哋本地需要啲咩改革咧？其實咧，我哋咧如果要去實行呢一個嘅容許與仲裁結果有關嘅收費架構嚟講咧，我哋需要有除咗立法嗰方面修動之外咧，其實咧我哋現在嘅專業守則我哋香港有我哋嘅法律嘅專業人員咧係有兩邊嘅主要有兩邊啦，一邊就係事務律師，一邊就係大律師。咁我哋事務律師同大律師咧都係受好嚴格嘅規例嘅，亦都有佢哋嘅自己嘅專業守則。咁我而家現在嚟講咧，呢兩方面嘅專業守則係唔容許咧，我哋係喺無論訴訟又好，喺仲裁又好，係唔容許咧事務律師同大律師咧係去同客戶達成呢啲與結果有關嘅收費協議嘅咁但係咧，如果我哋最後尾嘅結論就係話香港係適合做呢個改革嘅話咧，我哋需要咧係喺嗰度，即係話專業守則嗰度咧係需要作出適當嘅調整。但係當然我哋係引入咗呢個收費架構之後，我哋亦都會咧係去考慮，都係去諮詢公眾關於咧係我哋有啲咩保障咧係需要喺呢啲專業守則嗰度咧係需要作出調整嘅。因為咧以一個律師同埋一個大律師嚟講咧，係如果違反咗相關專業守則，都係對佢嚟講有一個好大嘅後果，可以係一個好大嘅後果。最後嚟講咧，我想再次強調就係話咧，我哋今次呢個諮詢嘅範圍咧，亦都係我哋嘅建議咧，只係局限於將呢個與結果有關嘅收費架構係加入仲裁嘅情況，係與現行嘅訴訟嚟講咧係完全係唔受影響嘅希望解答到個問題，唔該。
好，香港01。
01就想有兩條問題想問啦。第一就係見到嗰個不成功 低收費入面提到嗰個律師費咧係有個折扣率啊，想問下其實委員會有冇啲咩建議個折扣率嘅水平，或者係依家做法係點啦？第二個問題就係想問下嗰個收費上限水平咧，其實委員會有會唔會擔心，如果個上限水平定得太高嘅話咧，對香港嗰個仲裁樞紐啊或者案件嘅數目會唔會有啲影響咧？唔該。
我嘗試回答第一個問題先嚇。就其實呢個問題頭先都問咗一次嘅，就關於呢個折扣率嗰樣嘢。其實我本人亦都好同意頭先張主席嘅所講咧。其實呢一樣折扣率其實係律師同埋當事人之間嘅有個自由嘅協定嘅。咁當事人當然佢唔係淨係會去問一間律師樓，可能佢會有唔同嘅選擇。咁當然呢個亦都係一個商業嘅考慮。我相信呢個係第一個考慮。第二個考慮嚟講呢，亦都可能係關於嗰個官司本身嘅勝算，或者即係官司嘅意思，即係仲裁本身嘅勝算啦。咁其實嗰樣嘢其實可以好多唔同嘅因素嘅嚇。而我哋亦都暫時咧睇唔到有一個需要啦嚇，去話就呢個低收費嗰度，即係話如果個官司係最後尾個仲裁係輸咗嘅話咧，即係我淨可以收個低收費嘅情況，係應該定喺個乜嘢嘅折扣率嗰度咯。咁呢個其實因為我哋覺得香港嚟講一路都係奉行呢個即係自由嘅去到合約嘅自由可以去簽合約啊，達成呢啲協議。咁呢一方面我又唔覺得係有一個特別嘅需要去規管。咁但係咧相反嚟講咧，至於個上限嚟講咧，就係話其實可能有啲公共政策嘅考慮啦。因為咧就話正如我頭先所講過啦，其實就嗰個係一個純利潤嚟嘅。純利潤嚟講，準一個律師可以去攞到幾多純利潤咧？呢個就同話折扣方面咧，就嗰個考慮咧有啲唔同嘅嚇。咁樣咁至於話第二個問題就係話會唔會話定得太高就會影響咗嗰個香港嗰個嘅競爭力啊等等咧，咁其實我哋都係好認同咧，需要有一個恰當嘅上限嘅。正如我哋參考咗唔同嘅地區嘅上限啦，其實英國咧英格蘭威爾斯咧就用咗100% 嘅上限。咁關於呢個按條件收費嗰個上限啦，咁至於話按損害賠償嘅，可能我哋會考慮緊就係話其他地方有30% 啊嗰啲咁嘅上限。咁所以呢個咧上限嘅議題嚟講咧，都係我哋今次嘅諮詢文件裏面其中一個咧好重要，希望咧大家可以俾到意見我哋嘅地方嚟㗎。唔知主席會唔會有啲其他嘅補充 ？OK， 唔該。
仲有冇其他問題？如果冇其他問題嘅話咧，我哋今日個記者會咧就結束啦。多謝晒各位嚟到今日嘅記者會。Thank you for coming to our press conference.